this August gathering on a topic of great importance and which is close to my heart, namely environmental justice and climate change. I thank the Academy for giving me this opportunity to speak to you all in this 10th lecture of the Silver Jubilee lecture series. It is said that human body is comprised of 5 elements of nature, which teach lessons and inspire strength in the formulation of the character of the human body. The 5 elements are earth, which teaches us patience, love; air teaches us mobility, liberty; fire teaches us warmth, courage; sky teaches us equality, broad-mindedness; and water teaches us purity and cleanliness. Before I begin to say my few words and share my thoughts, I would like to say as to why I chose this topic. Firstly, the relationship between man and the environment can be traced to the very beginning of human existence. Human history has always been a history of interaction between man and environment. Second, the environment in which we are today is in a state of decline. I don't think there can be any doubt about it in terms of its quality, as we are continuing to exploit the Earth's resources beyond its replenishing rate. At this stage, I would like to recall the words of Justice Venkatachalaya as he then was, when he said in Mudagal, quote, "The tragedy of the predicament of the civilized man is that every source from which man has increased his power on earth has been used to diminish the prospects of his successors. All his progress is being made at the expense of damage to the environment, which he cannot repair and cannot foresee," unquote. The third reason is accelerating climate change is exacerbating social inequalities in the world. Fourth, we are at this crucial juncture where all sections of the society are required to work together to address the environmental concerns. The role of rule of law as well as the courts, particularly the constitution courts, are important in this regard. I have structured this lecture into 4 parts, but I will be concise and not long like in my judgments. Before discussing on environmental rights and duties, it is necessary to touch upon a few articles of our Constitution. You see, when the Constitution was enforced in 1950, the word environment itself was not there. The framers of the Constitution were more concerned with the political rights, social rights, economic rights. Environment there meant a good political, social, economic environment in the country, and not the environment in which we are speaking today in terms of air, water, and other resources, natural resources. Under the 42nd Amendment, Article 48A and Article 51A were added as a directive principle of state policy and as fundamental duty. And thereafter, under the 74th Amendment, when the Chapter 9A was added to give fillip to local administration and local self-bodies, Article 243ZD, Article 243ZE with regard to district planning and metropolitan planning were added, and the 12th schedule was added to the Constitution, that is Article 243W. The 1976 Constitutional Amendment shifted 2 entries from the state list to the concurrent list, namely forests and protection of wild animals and birds, so that it could not be left to the individual states to frame their policies. The nation had to, as a whole, had to do it. Therefore, the Parliament thought that it must have the right and the power to make law for the entire country insofar as forests and protection of wildlife, wild animals, and birds are concerned. We know through judicial interpretation how the Supreme Court and the constitutional courts, namely the high courts, in various decisions have recognized the right to live in a pollution-free environment under Article 21. Learned Chief Justice has come from Delhi. He wouldn't have to wear the mask in October, November in Karnataka, Chief. T.N. Godavarman is the one which defined forest land under Section 2.2 of the Forest Conservation Act 1980 to enlarge the scope to include a dictionary meaning, the meaning which is there in the land records, and generally when it is a statutory meaning under the Forest Act. Lafarge is a landmark judgment when it comes to implementing the environment impact assessment directives. Recently, Chief Justice Chandrachud, although by an interim order in Ranjit Singh, suggested that the people of India have a right against adverse effects of climate change, tracing a new right which is along with clean and healthy environment and right to live life and equality. Interestingly, the Supreme Court in 2019 in Hanuman Lakshman Aroskar brought about the new concept of environmental rule of law. We have heard of rule of law, which we know under the administrative law, the high courts, the Supreme Courts are implementing the rule of law concept. But in 2019, the Supreme Court said that the environmental rule of law seeks to bridge the considerable gap between environmental laws and their implementation and enforcement. Thus, this is only a bird's eye view of what has been done in various sectors of environmental law. But we have the 5 principles with regard to environment law, which I shall briefly touch upon. I'm sure this audience is aware of it, but just to make my lecture complete, I would like to touch upon briefly the principle of sustainable development, polluter pays principle, precautionary principle, public trust doctrine, and intergenerational equity. The term sustainable development came to be defined in the Brundtland report as development that meets the needs of the present without compromising the ability of the future generations to meet their own needs. Many a time, when the state or the project proponent says that this project is in line with sustainable development, what is it that the courts have to see? Not just whether to scuttle the project or whatever is to sought to be done, but whether the coming of the project would damage the environment surrounding it permanently or not. That is the approach which the courts must have. Polluter pays principle requires that the polluter rather than the government or members of the public should bear the cost of pollution. In Vedanta Limited, the Supreme Court noted that the polluter pays principle serves as a reminder that economic activities should not come at the expense of economic degradation or the health of the population. Next, the essence of the precautionary principle lies in the notion that decision makers should act in advance of scientific certainty to protect the environment. I shall speak about it a little later. Under the precautionary principle, once a threat to environment has been identified, action should be taken to abate environmental interference, even though there may be scientific uncertainty as to the effects of the activities. Recently, in Manashakti versus Union of India, this principle was applied. The Supreme Court struck down 2 executive instruments that allow ex post facto environmental clearances. Despite there being judgments, the Ministry of Environment and Forest and Climate Change proceeded to legitimize retrospective clearances under the pretext of SOPs through the 2021 Office Memorandum. In the context of the precautionary principle, the Supreme Court struck them down because when projects are allowed to operate first, and seek clearance later, there is no way to avoid or minimize the impacts that would have already occurred. It would be interesting to note that the former Chief Justice of Karnataka High Court and the former Judge of the Supreme Court, Sri Justice Abhay Oak, who authored the judgment in Vanashakti, has made a landmark contribution in this regard. His contribution to upholding the environment rule of law is immense, that a publication titled The Oka Effect was published on his retirement, highlighting his green legacy. The public trust doctrine recognizes that the state holds natural resources in trust for the benefit of the public. This doctrine is based on the principle that certain resources like air, water, forests have great importance to the people as a whole, that it would be wholly unjustified to make them a subject of private ownership. I am sure Justice Dinesh Singh and Justice Banerjee would know MC Mehta versus Kamalnath, where the park in Lucknow was sought to be changed to some other, and the executive acting under the doctrine of public trust cannot do that, was what the Supreme Court said. The concept of intergenerational equity suggests that the present residents of the earth hold the earth in trust for future generations, emphasizing that enduring obligation to safeguard the environmental heritage of the well-being of all. How have we fared in environmental jurisprudence? It is because of the increasing recognition of the constitutional conscience. The Supreme Court has been pushing for a shift from anthropocentric approach to an ecocentric approach to environmental issues. Anthropocentric is where the human being is made the center. But in ecocentric, it is the entire natural world and not just man. The Supreme Court opined that ecocentrism is nature-centered, where humans are a part of nature, and that non-humans also have intrinsic value. Other species, that is. In Center for Environmental Law, WWF, in the context of examining the necessity of a second home for Asiatic lions, the Supreme Court applied what is called the species best interest standard for the Asiatic lions. It is necessary to consider the issue from the point of view of that particular species and not from what the bureaucracy wants or the department wants or the government wants. I have pleasant memories of dealing with Suomoto versus State of Karnataka, sitting with the then Chief Justice Vaghela, when there were shocking deaths of several elephants in the Mysore forest area, and a committee was appointed by the division bench to give their recommendations, and we accepted most of the recommendations, but one recommendation we left to the state government to decide, and that was whether the golden howdah could be carried by the elephant in the Dasara procession. I thought, being the author of the judgment, that it did not just involve the elephant concern, but there were many other aspects which had to be considered. And so we said we leave it to the state government to decide whether the elephant concern should carry the heavy golden howdah. Despite many observations of the Supreme Court, having secured environmental justice and promoted the well-being of all living creatures. For example, very recently, the Supreme Court noting that the politician-bureaucrat-builder nexus has led to the doctrine of public trust being given a go-by. It declared the allotment and subsequent sale of reserve forests as illegal. This was again in T.N. Godavarman. Similarly, insofar as Chandigarh city is concerned, I had the opportunity to sit with Justice Gawai, now the present Chief Justice of India, with regard to converting in residential units into apartments in phase 1 of Chandigarh city. The Supreme Court held that providing something which would adversely affect the heritage status of Lee Corbusier Zone, who is the architect of Chandigarh city, without the approval of the Heritage Committee would not be permissible. We exercised our powers under Article 142 of the Constitution to issue directions to preserve the heritage status of Corbusian Chandigarh. I come next to the important part of my lecture, that is the challenges posed by climate change to existing legal order. I begin with an observation that the court's responsibility to provide relief in environment matters is increasingly challenged by climate change, and that courts need to be alive to this challenge. Climate change poses several challenges not just to stable environment but to human life itself. The right to health, the right to air free pollution, right to a pollution-free atmosphere, vector-borne diseases, rising temperatures, droughts and floods and storms are some of these challenges which are a result of the climate change. People who are living in or near lands vulnerable to climate change will find themselves being in a disadvantageous position than those who live in comparatively safer places. We always thought Bangalore was a very safe place. We are above 3,000 feet sea level. There is no flooding as such, there is no river. But look what is happening in Bangalore. One half day heavy rain and there are floods. Can you imagine we are using boats in Bangalore for our ingress and egress from the houses to come onto the main roads. Recently in M.K. Ranjit Singh, the Supreme Court held that the people of India have a right against adverse effects of climate change. That is a very important statement and observation, but the difficulty is as to how that right would be enforced. Deciding on claims involving climate change brings with it its own new challenges. I will highlight only two of them. The first challenge is that courts are not empowered to direct authorities to consider the contribution of a particular project when they are challenged to climate change. This is because the existing laws unfortunately do not require the agencies granting clearances to consider a project's contribution to climate change and the impact on it due to climate change. At this stage, I must refer to the recent advisory opinion of the 14-judge bench of the International Court of Justice on the obligation of states in respect of climate change. We have been reading about it in the press recently. Of relevance to us, the International Court of Justice reaffirmed that states must fulfill their duty to prevent significant harm to the environment by acting with due diligence. That states can be held responsible if they fail to take all measures which were within their power to prevent the significant harm. Recently, when the Glasgow Summit, that is COP26, was held, our Honorable Prime Minister presented India's 5 elements called Panchamrit to deal with the challenge of climate change. First, India will reach its non-fossil energy capacity to 500 gigawatts by the year 2030. Second, India will meet 50% of its energy requirements from renewable energy by the year 2030. Third, India will reduce the total projected carbon emissions by 1 billion tons from now onwards till 2030. Fourth, by 2030, India will reduce the carbon intensity of its economy by less than 45%. And fifth, by the year 2070, India will achieve the target of net zero. In light of the above commitments India has made before the world, it becomes more important to determine how much each project and how much each diversion of forest contributes to climate change. Therefore, it is the responsibility of every citizen to ensure that this Panchamrit actually comes in force and is implemented. Particularly as regards large-scale projects, It may be necessary for the law to mandate climate change impact assessment. In fact, even as regards smaller projects, the law does not seem to require to measure the impact of forest and other natural bodies in regulating the microclimate of the area they are situated and how they reduce the impact of urban heat island effect. The second challenge is the challenge of establishing causation. The complex and global nature of climate change can make it difficult for a court to attribute responsibility for climate change to any particular entity. In this regard, it appears that the recent developments in attribution studies are helping to bridge this gap. Attribution studies are now being used to link human activities to observe changes in the climate system and corresponding impacts on natural and earth systems. Nevertheless, it is necessary that judges and advocates are trained to handle and be familiar with such reports. Coming to the crucial aspect of my lecture is reimagining environmental justice. I will present a few of my thoughts in the spirit of our Constitution. Of course, it is difficult to provide an exhaustive account of the same, but I will touch upon 3 points. First point is that environmental justice should not be seen in isolation. Rather, it must be seen as a part of a broader framework of justice. What are the implications of the point that environmental justice should be a part of the broader framework of justice? The first implication is that this point provides deeper link between human concerns and environmental concerns and suggests that both have to be dealt with simultaneously. This is also reflected in the Paris Agreement, which is a legally binding international treaty on climate change. The second implication is that it rejects an attitude of dichotomy between humans and the environment. I am reminded of a popular phrase in this regard: humans are a part of nature, not apart from nature. Landscapes shape and are actively shaped by human interactions. In this regard, the scheduled tribes and other traditional forest dwellers' recognition of their rights Act 2006 is particularly relevant. The third implication of this point is that it rejects the assumption that merely because a particular policy promotes environmental justice, it promotes human rights. For example, several projects involving road widening in certain areas which are ecologically fragile are promoted. Apart from ecological implications such as loss of forest cover, greater chances of soil erosion, etc., the broad social implication is that they make the area more vulnerable to disasters. The widening of roads make the tourists have a better access, increase pressure on resources available there, and thereby further increase the vulnerability of the people living there. I am sure the people living in certain parts which are vulnerable, they would not like to have tourists at all. The road to sustainability requires that we build lesser roads in certain eco-sensitive zones. The fourth and the connected implication is that it rejects the othering of nature. Now, what is this othering of nature? Othering is the process of distinguishing and labeling a person or group as different from oneself. This process of othering is very evident in the use of the terms like natural disasters. In my opinion, there is nothing natural about a disaster. Disasters occur because we human beings have designed our living spaces without regard to the interaction with environment. For example, a significant reason why floods occur on built-up areas, on water bodies, is one such example. There is no way for the water to flow. The important principle of water is it finds its own way. And when there is an obstruction to the flow of water, things like what happened in Bengaluru, Chennai, would happen on account of heavy rains. especially in Bengaluru, which is a city which does not have a perennial river. Lakes were the predominant lifeline for people living here. But excessive urbanization, major encroachment and pollution of the water bodies have created a shrinkage not only in the lakes but increased the concrete jungle. Earlier, when it used to rain, these water bodies acted as a buffer. In fact, I think the lakes in Bangalore, they're all interconnected. When one lake used to fill up on account of there being rain in one part of the city, the excess water would flow to another lake. There was never used to be a flooding. But if on lakes, on Rajakalways, on channels, on waterways, we have construction, then where will the rainwater go? One is excessive rain. We don't know whether there is really excessive rain because of climate change. They say, oh, there is excess rain because of climate change, therefore we are having flooding. Nobody is saying that we are not allowing the water to flow by having this cement jungle around us, and as a result the water is being restricted in the city itself. So it's not really due to excess rain on account of climate change, but on account of there being an obstruction to the flow of water that the city is getting flooded. Earlier when it used to rain, the water bodies acted as a buffer, but now the water does not have space due to these encroachments, leading to increased instances of flooding. Despite we humans to blame for this, we call it a natural disaster, and we have a disaster management department to look after natural disasters and shift the blame on nature, thereby othering it. The second point is the rights as creating institutional demand. The second point which environmental justice requires us is to view fundamental rights enshrined in our constitution, not only as rights empowering the citizens, but as creating demands on institutions to ensure that such rights are exercised well. We have the right to a clean and healthy environment. The corollary to this right is that the institution which maintains such environment, not merely the Department of Ministry of Environment and Forest Climate Change, but even locally, the municipality, the local bodies, the municipal corporation, as well as the state governments are bound to act in such a way that this right is protected. Therefore, I said those sub-articles under Article 243 of the Chapter 9A have included all this. Another corollary to this right is to ensure that institutions that are in place to protect such rights are adequately equipped. One more implication is that the government cannot keep its hands off by merely saying that there are enough regulations in place when in spirit and in implementation they do not promote environmental justice. For example, there was a Rajya Sabha Unstart question in 2023 regarding the utilization of what is known as the CAMPA funds. The context of this CAMPA funds is that whenever a project proponent wishes to divert forest land for some non-forest purpose for a project, they have to pay a certain levy called Compensatory Afforestation Fund and Net Present Value (NPV). The answer to the question was that between 2017 and 2022, the total CAMPA funds received and transferred to states was around rupees 57,325 crores. But the startling fact is that out of that nearly rupees 38,698 crores were unutilized. I hope I am wrong in this. When laws are enacted in furtherance of a constitutional duty, it is necessary that those laws are implemented keeping in mind those duties. Now let me extend this line of thinking to the new right which the Supreme Court has created in M.K. Ranjit Singh. States institutions to include climate change considerations in all their policies and decision making. If any policy is to be made, whether the aspect of climate change is taken into consideration at all is important. We have various boxes to tick off. Widening of the road, cutting of so many trees, having this concrete structure, having that concrete structure, this facility, that facility. Where is the box to tick off on the impact of this project on climate change? Therefore, every policy or decision making must have the inclusion of the impact of climate change on that project. It also necessitates creation of institutions that promote a climate resilient future. Of course, keeping in mind that climate justice is part of a broad framework of justice. The fourth implication is that we must continuously invest in new technologies that will help improve and ease data collection. It is only when we have data that we can exactly know what the issue to be addressed is. While of course I am not an expert in technology, my suggestion is simply that we must embrace such technologies that ease data collection when they pose low to no risk to environment and promote the fulfillment of constitutional duty. Otherwise, the intrusion on nature would be pervasive and at times irreversible. The third point is that environmental law is hot law. What is the meaning of this? This description that we must be alive to the fact that environmental law is also hot law, it was given by a scholar, Professor Elizabeth Fisher, in her paper, Environmental Law as Hot Law, Journal of Environmental Law. What is meant by this description is that the agreed frames, legal and otherwise, for how we understand and act in the world are in a constant state of flux and contestation. But what does this principle really require us to do? In essence, it says that once a threat to the environment has been identified, action should be taken to abate environmental interference, even though there may be scientific uncertainty as to the effects of the activities. But what is the threshold of this threat? If the threat is too high, the constant caution will lead to fewer decisions and less progress. If it is too low, then there is risk of future uncertain damage. Therefore, courts always have to balance according to the facts and circumstances of the case. That is what is called hot law. It is perhaps for this reason that in Gene Campaign versus Union of India, popularly called the GM Mustard case, sitting with my learned brother Justice Karol, I differed with him and the matter has been now referred to a 3-judge bench with regard to the application of the principle, and the matter is now referred to the larger bench. The application of the principle is the precautionary principle to genetically modified mustard. Genetically modified food in the form of, not food, in the form of cotton we had. We had to some extent BT brinjal, but that is all given up. Now they wanted to have GM mustard, and I had my own doubts about not only the process in which the decision was taken, but on the very aspect of whether we could have GM food at all. But I am not an expert to comment as to whether India should have GM food. That is for the experts, and therefore without going into that aspect of the matter, only on the process on which the decision was taken, I struck it down. Now, what are the implications of environmental law being hot law? The first implication is that our decisions, whether it is the court or the government, must cater to what the context requires. A good example of this is what happened in the Bhopal gas tragedy. Even before that, the doctrine of absolute liability in the case of the oleum gas leak in Delhi was applied. But the Supreme Court invoked the parens patriae doctrine when it said that the company must settle, and a settlement in the quantum of compensation was arrived at. The context requires that we promote policies and interpretation of laws that places justice at its heart. The second and connected implication is that application of the content of the principles of environment law cannot be settled. The Supreme Court has said in several judgments that courts have to be mindful of well-settled principles of environment law that need to be invoked when environmental related issues need to be decided. How the content of these principles should apply to each issue is something that is not settled. There is always a kind of balancing act which has to be done by the court. That when the balancing is done, due regard must be had to constitutional aspirations, human rights and environmental rule of law. The third implication is that in light of the earlier mentioned context, we need to seriously think of declaring certain areas as inviolable. Areas such as biologically significant areas, BSAs, heritage sites, HS, biocorridors, BC, and eco-sensitive zones, ESZ, are considered to have seminal importance in harboring biodiversity, regulating local environment, and contribution in reducing the acceleration of climate change through carbon sequestration. Of late, some governments and corporations have been creating infrastructure and promoting tiger safaris in the name of ecotourism in various tiger reserves and wildlife sanctuaries. Government should ensure that the ecosystem of the area is given paramount consideration before approving such tourism, and in certain cases should not even approve of such tourism. Many of us have gone to tiger safaris, and we have the famous Bandipur Tiger Project. I would implore the Honorable Chief Justice to make time and go there. But see the atmosphere which we create for our tigers. We all get excited when we see the animal, and the poor animal is often distraught, confused and angry. The kind of pollution we create with the motor vehicles going one after another in the same direction because something was spotted behind the bush or the tree, and the kind of noise that we make when we really spot a tiger. Let us give space to our other species and not just look into ourselves. Therefore, let me now summarize the key points I have said during my lecture. That we should have a constitutional conscience to shift from an anthropocentric approach to an ecocentric approach to environmental issues. That climate change brings with it several new legal questions, and the court must be alive to such new legal challenges through creative interpretation of existing laws. That environmental justice should not be seen in isolation. Rather, it must be seen as part of a broader framework of justice. Before I conclude, I must say that law alone is not enough to protect our environment and deal with climate change. It begins at the level of the individuals as well. We all know of the segregation of waste, solid waste management, right at our doorsteps, wet waste and dry waste. Even if we segregate, what happens to that waste afterwards? It is only when it begins at the level of the individuals as well. It is only when our thoughts are pure that our actions cause minimal suffering to others. This is the essence of the fundamental duty enshrined in Article 51AG of the Constitution. I will really end now with the famous quote by our former President, Dr. APJ Abdul Kalam, when he said, quote, "Where there is righteousness in the heart, there is beauty in the character. When there is beauty in the character, there is harmony in the home. When there is harmony in the home, there is order in the nation. When there is order in the nation, there is peace in the world." With this, I thank each one of you for your kind attention. I wish the Honorable Chief Justice of Chief Justice of Karnataka, the President and Governors of the Karnataka Judicial Academy, the resource persons, the director and her team, and the trainees, and each one of you all the very best. My good wishes to each one of you. May this academy, which has completed Silver Jubilee year, be a beacon of knowledge and endeavor in building character and personality of trainees who are our judges. Thank you and namaskar.
Thank you, President and Present Executive Chairperson, Karnataka State Legal Services Authority, to join in felicitating her late speech.
Honorable Justice B V Nagarathna, Judge Supreme Court of India, Honorable Chief Justice Vibhu Bakhru, Chief Justice High Court of Karnataka, my esteemed brother and sister judges, directors of the Judicial Academy, judicial officers, staff, law clerks, law interns, former judges of the Karnataka High Court, ladies and gentlemen. It's indeed a privilege for me to deliver the vote of thanks on this momentous occasion, the final, the 10th Silver Jubilee Lecture Series of the Karnataka Judicial Academy. At the outset, I would like to extend my heartfelt gratitude to Honorable Justice B V Nagarathna for delivering a truly insightful and thought-provoking lecture on a topic that holds great relevance in the contemporary judicial landscape, environmental justice and climate change. Justice B V Nagarathna has not only explored the intricate nuances of environmental jurisprudence, but has also illuminated the practical implications of the law, making it much more accessible and comprehensible for all of us. The way she broke down complex legal concepts into digestible elements is a testimony to her vast experience and wisdom. We are fortunate to have had the opportunity to listen to such an enlightening discourse. Thank you, Madam, once again.